All right, welcome everybody. We're going to get started. We have with us today Gene Kimmelman. I think, this is another in a multiple series of topics on tech and regulation. It's really the core of it is Gene. We have Tom Wheeler, former chairman of the FCC. John Salad is here. Unfortunately, he couldn't be here this week for some personal reasons, but he's normally here as well. And it's a terrific group when you think about their experience. Gene at the Department of Justice and more broadly, Tom at the FCC and more broadly, both private and public sectors. John Salad is helping oversee the Colorado's lawsuit against Google for antitrust violations, some of which seem to be coming closer to a head anyhow. And so we will see how all that plays out, but this is another in that series. And I just want to welcome Gene and Tom and all of you, and we will open it up for questions towards the end. But with that, Gene, it's all yours. And I'm John Haigh. I'm the director. I'm the co-director of the Mosavar Rahmani Center for Business and Government, in case you were wondering.
All right, thanks so much, John. So today we're going to talk a little bit about what we anticipate is a new law in the United Kingdom that has been proposed and which actually we think is very likely to be enacted, and that's why we're going to spend a bunch of time looking at it here. Going to look at how this new law will expand the power of the Competition Markets Authority, UK's competition antitrust regulator, how it fits in with the underlying power of the CMA in the UK, how it relates to what other countries are going to do. I'm going to touch on Germany for a second, but a little bit more on Europe. We talked about what the European Union has done in the fall when we did a presentation. I'm going to kind of bring some of that back here. And then, of course, what are the real implications of this in the marketplace and for the US? So that's going to be the framework here. I want to start off first by thanking Sadev, Jordy, Nelly for helping put all of this together. It wouldn't have happened without them, so thank you for all your help. The goal here I want you to be thinking about is, as we go through the details, and the slides will have a lot more detail in them than I am going to touch. So the slides are more of a resource for you to think about and look at later. But the goal here, from my perspective, is to imagine a world that's changing around the US, where much less is happening, and how that will implicate what we have to consider in this country as it unfolds in Europe and in the UK. So let's see if I can accomplish getting some of those thoughts going for you. Why are we even seeing countries contemplate such detailed new legislative action to look at digital platforms? Again, we went over this when we talked about Europe in the fall, but just to kind of bring it back, there are some unique elements that we're all experiencing with digital markets. I mean, imagine Amazon as a marketplace that brings together massive numbers of sellers, merchants, and then consumers buying off of them. Google as a platform for advertisers and for publishers with a real-time display advertising structure that brings together everybody who sells and buys in that marketplace. Apple with its app stores, and Google the same, where you see everybody who is a developer of new apps, merchants who want to sell through the app ecosystem, and all the consumers who want to download those apps and use them and purchase from them. And in the social networking area, Meta, it could be TikTok, all gathering people together. And what they all have in common is this nature of a two-sided market, which brings people together on both sides, and where there are unique economic features that we're seeing in the digital marketplace, where there's enormous capital investment up front, but then once you get everyone on a platform, interacting with each other, the costs go down dramatically, often to a marginal cost of zero in many instances, and where you have enormous status power of bringing everyone together, having them assembled, and having it be a little inconvenient, maybe even worse, to leave and go somewhere else. Why would you when you're with everyone else you want to interact with? And so this then is brought together with other attributes that we see as powerful forces: use of intellectual property, patents, developing all kinds of new innovations, companies that become extremely disruptive as they innovate, devise Chat GPT coming out of nowhere versus search. I mean, the explosion of innovation is quite special in this space. We've always had vertically integrated companies, the people selling off of their own platform, but maybe some unique attributes here where Google has a suite of services that nobody else has been able to put together that it can combine with search. So you see some special things. They're not totally unique to digital markets, but when you combine them together, what do you get? You get enormous power. And just to remind you of, again, why would countries be looking so seriously at legislating, changing their laws? Well, because they're getting barraged. Everybody who sells on Amazon is complaining increasingly about Amazon's control of their data as merchants on their platform. Same in Google's ecosystem. Google controls all the data. Advertisers and publishers claiming they can't get insight as to the effectiveness of their own ad campaigns or how whether they're getting maximum price for advertising on the content on their own websites as content providers. In the App Store, a 30% take rate for Apple for every app developer coming on, having to sell through the Apple controlled payment structure. The complaints are just ongoing drumbeat of concern. And I think that's why we're seeing so much activity in this space. So the UK, a number of years ago, commissioned Jason Furman, from here, to do a report with a number of other experts and as to whether there was a need for a change in law in the UK. And they developed a report, and it focuses on many of the things I just mentioned: markets tipping, concentration in the markets, little entry and expansion in the markets, and the power of data all driving this. So out of this is why we see the UK government moving forward. On Wednesday, we're going to have Amelia Fletcher, who worked with Jason on that report, lead the study group. And she's been on the board of the CMA and has some really unique insights about how this has all developed in the UK. But what is being proposed here is a framework built on a new definition of dominant companies. We've never seen this before in law anywhere other than Germany that we'll touch on, which is companies with strategic market status. Now, why do I say it's unique? This isn't antitrust. This isn't a detailed analysis of whether you're a monopolist or running precise concentration levels to look at whether you're uniquely positioned in a market to leverage and harm competition, which we do in the US and so many other competition authorities do. This is a targeted focus on companies strategically situated. Now there's overlap because if you look at the elements, concentration, power, size in terms of revenue are elements of it, but it's really very much focused on a strategic ability to have too much power in the UK market. So while it is company specific, as one might think of in antitrust cases where you're looking at the behavior of one company, this isn't antitrust. This is a regulatory frame. So it's something really quite new that we have not seen before. Um, these strategic firms are to be thought of as powerful in three particular ways, whether they're somehow interfering with fair trading practices. So thinking about what is a reasonable commercial relationship in that particular platform market, whether it's somehow allowing, enabling, or interfering with open and free choices in those marketplaces. And then trust and transparency, whether there is enough information for the business users on those platforms, for consumers in general, to really understand whether they're getting what they think they should be getting and how they can negotiate with the platforms. So some basic principles that are driving the legislation as it unfolds. And the question is, how does this get put into practice? The entire framework coming out of the Furman report and in the legislative language is a kind of discussion of a code of conduct to be collaboratively developed between the companies, the regulators, the public, open proceedings, with a focus on particular types of harms: discrimination, tying and bundling, opaque information flows that harm a competitive process or deny information to the users of the platforms. Think about the unique way in which this is put together. Strategic company looking at that does, as a platform, many different functions. Google is search, Google is App Store, Google is Android, Google is an entire display advertising apparatus. But it's not an antitrust case where you look at a particular behavior. They're looking at the entire firm and the ecosystem of the firm to see whether there are these abuses going on and what needs to be done to address them. The law is being proposed gives the CMA enormous discretion, creates this new digital market unit within the CMA to oversee this work. And so you can imagine groups of specialists, lawyers, economists, technologists, focusing on Google, focusing on Meta or Apple or Amazon and others, possibly Microsoft, and looking at whether there are abuses within each function and across these functions. Now that's a rather specialized kind of framework for targeting strategic companies in a marketplace that I'm not sure we've seen developed anywhere else. And even as this is unfolding, waiting for legislation, the UK isn't waiting. There has been a shadow digital markets unit in place since shortly after the Furman report that's been developing. I believe they now have more than 100 people working on these issues across these few strategic companies. So they are busy. The other unique attribute here, as I said, it's not really antitrust, is as they target these behaviors, they're not really requiring in the law that the Digital Markets Unit, the CMA, as it challenges companies, prove a specific competitive effect, to prove a specific harm to competition. They have much more broad categories about reasonable business practices and fair treatment of companies on their platform. Again, much different than antitrust. So this is an enormous set of powers that are being handed over to effectively a new regulatory body within the CMA, but it's not done without balance. And as I said at the beginning, it's been framed as if it's a kind of code of conduct. And so it's fully participatory for the companies. They're involved, they're open processes, they have a number of protections here. If they can show that what they're doing is necessary, objectively justified, based somehow on efficiency, innovation, or benefiting consumers, then those are exemptions from any of these interventions that the CMA is otherwise entitled to exert here against the companies. There is an appeals process. It is generally framed as a procedural appeals process, not a revisiting the facts of each case. And this is not unique in the UK, because even for the underlying power of the Competition Markets Authority, when they prosecute for antitrust, they're generally given substantial discretion, almost like a regulatory agency promulgating a rule in the US. It'd be something similar to more like APA review. You're only overturned for abuse of discretion. So here, in designating who is strategic, in identifying the behaviors that are harmful, the failure to share information, the failure to treat everyone fairly in a commercial sense, all of this can be challenged, but really fundamentally it is a matter of whether the procedures have been appropriately followed, not second guessing the CMA. And the penalties are quite large. Now, how can we think about this? Well, there are a couple examples where the CMA has already taken action, and it looks like this is the way they might be approaching things as they move towards the creation of the Digital Markets Unit. For publishers, they're demanding that there be a negotiation for payment for the content that publishers provide through advertising intermediaries on platforms, where now the claim is they're not getting fairly compensated, that they offer enormous value in their content and they're not seeing their fair share of that value returned through the ad revenue from advertising on their sites. It's a recommendation that they negotiate directly between the advertising intermediaries, the platforms, and the publishers, but there's a stick behind it. Probably most importantly here, the greatest complaints, as I said at the beginning, from publishers and advertisers have been, we just don't know whether we're getting what we deserve. We're not sure the metrics of what our ad campaigns are delivering, because Google doesn't share it with us, or Meta doesn't share it with us. It's all kind of put it into the system and trust them. So probably the biggest value here that they're offering is this transparency requirement, to open up the system to show how the online display advertising world and the world for Meta of its internalized advertising system really functions. They're doing a similar thing on interoperability. A lot of complaints, again, as I mentioned earlier, about App Store practices. Is the 30% charge from Apple really market-based, or is it expropriating the value of what app developers are really putting through their system? They're going to require interoperability between Android-driven services and the iOS to test this out. So pretty hard-hitting things that are starting to bubble up in the UK already, and you can anticipate more of that with the passage of the legislation. So let's just look at Germany for a minute here, just to say that it's not just the UK, and we're going to get back to the European Union in a minute, but Germany also passed a law in 2021 that updated their competition standards, very similarly targeting unique companies that have kind of special power in the marketplace. So in that way, very, very similar to what the UK is considering. It's an interesting framework here. Again, looking at what are reasonable commercial practices. The words are different, but you can see it gets at a lot of the same type of behavior, preferencing of your own products and services on your platform, tying and bundling services together, failure to provide adequate information for choice, both on the business user side and for consumers. So they just applied this in Germany against Google with a prosecution based on failure to treat publishers fairly for data processing. So this shows very much that there is a bit of a drumbeat here of consistent interventions related to making data available, giving users, business users, choices as to how they can work with intermediaries, third parties, not just the Google as a platform or Meta as a platform, to run their own ad campaigns and maximize their revenue for online display advertising. This is just a timeline I wanted to show you about how the UK process is unfolding. And what I think we're getting close to a point where we think the new law will be enacted, probably in the fall, hopefully in the fall. But the main thing I wanted to point out is Germany has a law, Europe has a law, the UK is about to have law. This is actually moving quickly compared to what's going on in the US. And that's really important. And not just quickly, but it has been a consistent buildup of skill and know-how in this shadow agency for the last 3 years. So they're going to hit the ground running. Not going to do details here, but the critical thing is you have countries focusing on specific content. You have the UK approach, which is more like this code of conduct and principles. In a way, I'm not sure it matters that much because they're all circling around the very same behaviors, the very same complaints of third parties about abuses on the platforms, and they're just different ways to go about them. But let's look back now a little bit at what's happening in Europe to place the UK in the right perspective here. Europe is implementing the DMA. I'm going to give you a quick review of this in a second, but just to think about this, 2024, it takes effect. And takes effect means that the companies that have been labeled the kind of platforms with the kind of services that need to be regulated have to submit compliance reports in the first quarter of 2024. So a year from now, they have to be in compliance, otherwise subject to massive fines and penalties. The key elements here, which we talked about extensively in the fall, I'm again not going to go through this in any great detail, but I want to point out, contrary to what I just described for the UK, this is not principles-based. This is a set of thou shalt not, you may not, you must. Clear directives as to what can and cannot be done for certain particular functions by certain kind of companies that have this gatekeeper status as kind of dominant players in markets. It will be a analysis, apparently, of each core platform service. It's defined in the law, and whether the company has met the obligations. So let's go on, reminder as to what these obligations are. They're pretty vast. You cannot use your data gathered as a dominant platform gatekeeper across your services. You may not use third-party data to be combined with your services without the consent of the third party. You must make your data relevant for publishers available to publishers, relevant for advertisers available to advertisers. Must be transparent, must be open. There are interoperability requirements for messaging across through app stores. No tying of any of your services, core platform services, with any other services. I mean, very extensive, detailed obligations. But most importantly, they're precisely written for specific functions, not like the UK, reasonable commercial practices or unreasonable discriminatory actions. Very precise. So how are these things going to work together? Really hard to say at this point in time. But I think what we know from talking to each of the regulatory bodies is they're all talking to each other. They're all working closely with each other with slightly different mandates, slightly different focal points. But you can imagine some interesting things arising as they do this. The DMA says for a search engine, you may not discriminate in ranking and indexing. Well, are ranking and indexing the only things that Google does with search? Not really. The whole advertised set of search results that you see is driven by what? Who pays them the most for advertising? They don't call that ranking or indexing. That's just their advertiser delivered a set of suggestions. And there are like a zillion other things like this. So does the DMA capture it or not? Unclear. Google will keep doing what they do. There could be a dispute about what needs to be adjusted or not. Could be appealed. Could be that the European Commission has to go back to the Parliament and seek amendments over time if certain things don't fit within the mold. But imagine that in the UK context, which has a much more broad set of principles. Reasonable commercial practices. If some of that advertising presentation isn't a reasonable commercial practice, they can intervene. They can require behavioral changes, structural changes, much broader authority there. On the payment options, app developers have been complaining that they can't sideload, they can't bring in their own apps into the iOS ecosystem without meeting all of the terms and conditions that Apple imposes for every app in its app store, described as unfair, interfering with their business practices, a lot of it unnecessary. They also have to use their payment system for in-app purchases, also described as unfair and inappropriate. Well, the DMA says you have to do side loading or you have to offer multiple payment system options. The German version actually says you have to do side loading and multiple payment options. I'm not sure whether the language difference will get worked out and harmonized in some way, but assume or means one or the other. I don't think app developers are going to like that. I think they're going to want both. Under the CMA's power, you can require both. You can require other things. Again, it's general principles as to what would be fair commercial practices and what are reasonable interoperability requirements in an app store. So we could see a number of things where there's greater intervention in one jurisdiction, or you might even call it filling in gaps in one jurisdiction versus another, while the other tries to figure out how it's going to deal with what might have been not the exactly best choice of words in a law that need to be somehow adjusted over time or litigated to figure out exactly what they actually mean. So I think you're going to see a number of things develop in the UK that might be a little different than in Europe. And the best way to, I think, understand this is to go backwards and stop thinking about the new law and think about first the old law. Because one power that the Competition Markets Authority has that I'm not sure I've seen any other antitrust authority, certainly not in the US, is the authority to do market studies and recommend market structures in a sector and then act on that, including behavioral and structural intervention. So the UK has periodically done detailed investigations of whether things aren't working in a market. It's not about whether someone broke the law. It's not about did Google cheat in search. It's more, is search a monopoly? How many players are there in the search market? Does this reflect real market conditions, or is it somehow, is there some impediment to entry and expansion in this market? It's all about market structure. And then the ability to propose a restructuring and act upon it. Think about that. That's not a monopoly case in the US where you say Google did these 5 things or Meta did these 3 things. And because of that, we are going to say you need to divest this asset or that asset. That's a long, drawn out, did you violate the law and how did you violate it and what's the right remedy? No, this is the market structure adequate to promote competition? Maybe no one did anything wrong, but it could mean that you need to restructure it. And the UK has given the CMA the power to trigger that. So this is a little bit of what led to open banking a few years ago. Some of you may have heard of this. There was a market investigation, the banking sector. Nobody was switching banks. No new banks were entering the market. Banks were not innovating. There were a whole set of things that were laid out about problems with concentration in banking. And to the best we can tell, open banking owes a little bit to that, or maybe a lot to that, where the banks thought, oh my God, we might get broken up. The government is seriously considering this a major problem. And fintech firms were starting to nibble at the edges and wanting to come in and enter. And they came to the table. And open banking was driven by the government, but with the banks involved, with really requiring open APIs for customer data, security protected, so that you could move seamlessly from one bank to another, to a fintech company, to an online startup or whatever. So this is an enormous power that the CMA has as its underlying power. In the new law, besides creating a digital markets unit, the government is actually expanding CMA's broad market authority, including penalties for failure to comply with these types of market investigations and studies. And then this is one of my favorite ones, giving them more power to amend remedies over a 10-year period. Think about what that could mean. You find that a market is concentrated, there's a bottleneck, someone is controlling access to business users, you require some kind of interoperability. Maybe you require a divestiture of certain assets. What if Google, because it's so powerful, has to divest Chrome? Is it abusing its market power using the browser to do other things? You have a theory, you have evidence, you have analysis. But what if 2 or 3 years into it, you find Chrome wasn't the problem, or that level or that precise form of interoperability really didn't create the bottleneck, it's something else? Well, if you're bringing an antitrust case, you'd have to go back in and reinvestigate and relitigate, and it would be hard and complicated, or maybe nearly impossible to do. So you're changing your mind again after you've prosecuted a company and you're going after them in a different way. Here, they're creating an entire framework saying, we expect that this is complicated and it will not be easy to solve for these kind of problems. And we're therefore giving you these new tools. And then add on to that, you can require the companies to trial a remedy. Okay, this is like, is it a privacy sandbox? I don't know. I don't know what the comparison would be, but let's try this interoperability, or let's try this new requirement for transparency and openness. And let's see how it plays out in a portion of the market or for a certain period of time. And let's do a careful analysis. This changes all the incentives of the company subject to this law as to how it's interacting with the government. Just think about it. It isn't like a fight. You win, I win, we fight to the finish. This is ongoing. And if I don't do this well, they're going to come back at me and make me rethink it, redo it, or whatever. So maybe I better come to the table. And you can see again how all of this then fits back in with the notion that this is supposed to be a collaborative effort, big sticks, enormous power, but everyone comes to the table, everyone shares their views as the best way to achieve the goal of the law, and it's an iterative process. So it's really, I think, going to be quite fascinating. And in many ways, some of you know, Tom and Phil Revere and I, a few years ago here, developed an idea of a digital regulator for the US. And a lot of the elements of what the UK has put in place were things that we proposed conceptually as a framework for trying to think about a modern version of regulation that was not wedded to old 20th century industrial thinking. And they're doing it with these new powers. So this may actually be some of the most powerful set of tools once implemented in the marketplace for the dominant platforms to have to deal with, in conjunction with those very specific mandates in Europe. But these could be, in some ways, the bigger sticks for iterative adjustments, experimentation with different kinds of regulatory remedy tools. And in some ways, maybe the companies will like it better. I mean, there's flexibility. They can argue that something is efficient, as you saw the exception in the law. They can argue it's actually better for consumers to organize a set of business practices one way versus another. So I'm wondering whether there's going to be some kicking and screaming, but some movement on the part of companies towards working more closely with the UK to develop workable models. And that allow them to run their businesses, but also open a lot of new realms of competition. So the other important thing to keep in mind as the CMA has these broad sticks is the thought about whether that little country that used to be part of Europe but then went through Brexit really matters. I mean, come on, it's the UK, right? Well, it's hard to say exactly why, but next slide, oh, we can jump to the. In the past, in antitrust cases, when the US tried to challenge mergers and lost in court, Sabre Farologics is a fairly recent one. The US didn't challenge Facebook's purchase of Giphy. The UK weighed in, and the UK said no to Sabre Farologics, and the deal went away. And the same on Giphy. Been cleared everywhere else in the world. Meta has not been able to close that deal, had to give up the assets. So that little country can matter. And as best I can tell, it mostly is because every one of these big companies needs to be in the UK for a substantial portion of their commercial activity. Even if it's not this specific transaction, if it's not this specific function, they all need to be there. So just something to keep in mind here. Currently, Microsoft is trying to buy Activision. They've been cleared for that purchase in numerous jurisdictions. The FTC is challenging them. But the CMA is also looking very closely at it. European Commission is looking closely as well, but the CMA is looking closely at it. And even if, I'm just going to say, if the US can't go forward with their suit to challenge the merger for whatever reason, and the European Commission can't or won't either, I would not be surprised if a block of that deal in the UK kills the deal. It's like a $60 billion transaction. So what the UK does, I think, can matter substantially. Next slide. And as I said, they have a lot of people working there. They're very busy. Look at this list. There's not a major company with a major set of activities in dispute that I can think of that isn't somehow covered by some ongoing UK investigation. And again, think about what this does in the nature of the structure of the law they have and the law that they are intending to put on the books. Massive focus on specific companies for a broad set of practices because they're strategically positioned in the marketplace, which usually means a lot of really expert lawyers, economists, technologists who try to learn everything they can about that company because they are looking at it so carefully. And look at all of these things where they have activities going on. And that power to use a market investigation and a market study to look at an entire sector. So when you see something, it's often the case in antitrust, you say, well, there are these cable companies. I know all of you probably like cable companies, right? Provide broadband service. But you can't always get the service to your house. You can't get them to come and repair. You say you want to switch service. You can't get them to come out. The price may not be exactly what you like, but you don't have very many choices. In the US, you look at that and you say, is that an antitrust problem? Well, who are they blocking from entering the market? Who is the competitor who's coming in? What's the problem here? In the UK, you could look at that and say, that's a highly concentrated market that deserves competition that's not getting it. We really ought to be restructuring things in order to get competition. It's a totally different framework for thinking about how to address problems in a sector. And with what they're doing on the tech sector, I think you can expect some substantial activities that companies are going to have to adjust their business practices for in 2024. And that's also the time frame in which we'll see Europe implement the DMA. So what does that mean? What do you think? I'm now turning it over to you. I think it means some people in the US are going to have to wake up. Maybe, maybe not. What do you think? Carolina.
You get this to her.
Wait a second.
Thank you. We saw the GDPR becoming the standard for privacy, right? And the American companies even adapting to that higher standard across the world. Do you see that's gonna happen here? And even with the UK, folks gonna say, no, I need to work in European continental Europe, so I'm gonna go with the DMA no matter what. Thank you.
So we can think of a lot of things that could happen. During the time that all of this is being put together in the UK and the European Parliament voted on the DMA, there were 2 antitrust cases in Europe against Amazon for harm to platform sellers, merchants on their marketplace. And by all press accounts, Amazon has come forward with a global settlement in Europe to commit not to using any data from the marketplace sellers to benefit their own products and services they sell on their own platform, and to basically end any discrimination in the buy box in how options are presented to consumers. Now, that happens to be exactly what the DMA calls for. It looks like it's almost precisely what the UK is going to be looking for. It clearly is also what the German law was targeting with inappropriate uses of information on platforms and opening that up. I don't think that's happenstance. I think Amazon decided the better path here was, in having to deal with these lawsuits and having to comply with the law, they were going to change their practices. Now, will they do that in the US as well as part of this business restructuring? We don't know the answer. I think the easy thing you can posit is where something requires substantial infrastructure investment and change, something like an interoperability requirement. You can imagine it being in the company's interest to do it globally as opposed to try to split off its businesses in different parts of the world. But that's not true for everything. An app store can charge 30% in the US and 10% to app developers in Europe. Probably not that difficult to differentiate that way. So you can see some things the same and some things different. And then another level on that, I think, is how will the public react? And that's when I say about, like, for the US, think about this. We can watch all of this happen across the pond. And we can say, oh, it's those Europeans. They do things that way. They like to regulate more. But if you see more startup companies trying to develop products and services in Europe, or selling first to the European market, or selling differently and more and better products and services in Europe, if you see better pricing for either business users and vendors on platforms and consumers who partake of those services, I think there's going to be an effect here. I think people are going to say, maybe we should have some of these rights and have some of the platforms should have some of the similar obligations here. I don't think it happens overnight, but I think these are the tensions I think that are going to be out there. Yes.
Thank you. I'm Ruchika. I'm from the MPID program. So one question that comes to mind, I like this, it's cool, but that also means that we need like an expert set of technologists, lawyers, kind of going in every time they have to examine a strategic market and what to do about it, which kind of puts it at odds with like setting precedents. So every time you have to, look into a strategic market, you start from scratch in some ways. And so I'm curious how you think this evolves over time as you do this process repeatedly, because it seems like a lot of resources, a lot of expertise, which may not exist like every time. Like we can think about it like going in once, going in twice, but what does this look like in the long run?
Yeah, it's a good question. I think right now, a lot of what you're seeing is pent up frustration at how antitrust has not either worked or been doing enough in almost any jurisdiction to solve problems people have identified, and how slow that process is, how there are not existing regulatory agencies in most jurisdictions that really have oversight over the tech sector and certainly not a deep understanding of data. And so it's a barrage of intervention and experimentation. And I think it'll filter out over some time. And that's what I think what's one of the unique things about the European model is it kind of builds in, well, the UK model builds in flexibility with this. We're going to adjust remedies. We're going to actually kind of experiment with specific companies in particular ways. The DMA has a different version of that, which allows for kind of quickly going back to Parliament, seeking an amendment, seeking broader authority, having a provision in it that says you can't circumvent the goals of the law. So there are different ways of trying to get at this. And I think what you're going to see both from the company side and the regulator side is we don't want to have to start from scratch on everything. We're going to want to set up some basic parameters and frameworks. And I think that's why, again, the UK framing it as a aspiration of a code of conduct is really to kind of build it in almost like you can imagine a set of known rules. So it is predictable. But I think what you're seeing now is just the barrage of we need a law, we need to do these things. There are a lot of practices happening that we can't capture through our antitrust litigation. So let's do something else. And then it'll sort out over some time. Tom.
Can I add one thing?
Of course.
The other lesson that we've seen in the UK, and Gene talked about the open banking initiative, is the open banking initiative originally started with the nine major banks, and now has over 90 banks. Not because they were required to do it, but because these 9 set a behavioral standard that became the practice that if you were going to exist in that marketplace competitively, you had to adhere to. And that, so we're going to see that as well, which is a down into the market. The SMS is a company, but you set a practice there, and it's then going to filter down into the rest of similar situated companies if the open banking initiative is to be believed.
Yes.
Thank you. So 2 quick questions, just building on the response earlier around, we're going to see a lot of the regulators trying to test new things out. I'm just trying to figure out, do you think regulators across different countries will change how they cooperate and how they engage with each other and potentially tackle issues that might be legal in one area, like one jurisdiction, but not in the other jurisdiction? For like example, America versus Europeans or the UK.
Yeah.
And just a quick cheeky second question. I was going to say, have you spoken to Stephen Gibson about it? Because as the chair of the UK Regulatory Policy Committee, he must be in the middle of all of this right now. And I'd be curious to know if you've had any chance to pick his brains.
No, not. I haven't picked his brains. We will try to. Maybe we should be doing that next. Oh. Yeah, so we should get together. I do think that you're going to see regulators getting together. In antitrust, they do this. And what's I think really exciting about this is that governments are giving antitrust authorities broader authority that is also regulatory, which most of them haven't had before. And so that's going to be a new set of conversations across what do you do with antitrust and what do you do with your regulatory powers, and when do you use which, and again, where do they go? I mean, the Amazon settlement is a really good example. They settled antitrust cases, but they did it with a remedy that was precisely what is being called for in the DMA. So you can see that there are cross-cutting things across different legal doctrines. And I think in cross different jurisdictions, regulators will be talking to each other about how do you leverage one versus the other, which is the better tool, which is the best way to frame up what you're doing. There was a press account recently of a change in the complaint the European Commission has, I believe, against Apple for app stores, and they adjusted the complaint. And at least in the press, some of the conjecture is they've adjusted the complaint to comply with the way they have framed the obligation in the DMA so that their antitrust action is in total parallel track with what will be required in 2024 under the DMA. So I don't know if that's true, but you can imagine that that's within one jurisdiction. You can imagine across jurisdictions, people thinking about how do you mix and match the tools they have and which ones work better. Yes. Yeah.
That also fall under GDPR, for example? Could there be a case where you have a violation of GDPR plus a violation of the new regulatory regime? And if that's the case, could you argue in some way that that's double jeopardy and you can be prevented,
Yeah, that's the issue of being responsible under multiple laws and whether they conflict with each other has come up. This is going to be playing out in the courts in Europe. It's been identified in the DMA. A good bit of the language in the DMA is about conforming its requirements with GDPR. So there's a full awareness of that. Also, if Germany goes forward with its publishing case, as I described earlier, it has to be consistent. If it covers a service covered by the DMA, it cannot go outside the bounds of what the DMA requires. So there are a variety of guardrails there against double jeopardy, but it will be highly contested, I'm sure.
Paulo Carvão with the ALI. Back to your point on impact to the US, or if we may have an impending event, depending whether the Supreme Court takes the lead from some of Justice Kagan's comments of flipping the issue back to Congress. So if that happens, and what would your crystal ball say, right? First, would Congress act, and in what direction?
I think it's like the pot is simmering a little bit. There's a lot of discontent in the U.S. markets, just like I described here. It hasn't bubbled up, unlike Europe, but it's simmering, and people are complaining and trying to figure out what is the appropriate accountability structure. So whether it's content moderation that has been in the Supreme Court with a law that is not clear exactly how it fits with all the new developments in online information distribution, or whether it's these competition issues or just the power of data and artificial intelligence. I think Congress is going to keep having to think about what they can do, what they can get together to do, which isn't easy, to actually create some kind of public accountability for these companies. I just think that the pressure will not go down. It will just keep increasing.
So I'll take the prerogative of having the mic. Couple questions. In the United States, it's not an antitrust violation to have a monopoly. Right. So market power isn't sufficient to cause an action in a court of law for antitrust violation. You have to have some other kind of behavior like tying or price fixing or refusing to deal or exclude, preferential, all those kind of things. But the way you describe the CMA's action, it can be just based on market power, right? And I'm trying to figure out how those two conflicting approaches and then the institutional bodies that are responsible for enforcing them kind of play out, which is really kind of what's going to happen in the US versus what's going to happen in the EU, what's going to happen in the UK, kind of as these different standards play out. It's hard for me to imagine that the United States can keep pace when their system is a court-based review of which we've seen historically. Monopoly actions take forever and oftentimes just lead to a settlement but no real conclusion.
Yeah. So I use the example of the threat of breaking up the banks in the UK to get open banking. So think about that for a minute. All those banks were brick and mortar in the UK. That's not Google, Meta, maybe a little bit of Amazon, Apple. These tech firms are not going to be broken up in the UK, even if they are found to be totally dominating a market. I think what you'll see is a lot of the behavioral restrictions related to not preferencing, sharing data, opening up, giving people more choices, possibly interoperability requirements. As all of that plays out, I find it hard to see how, I mean, you could get settlements of antitrust cases in the US that reflect those kind of changes. I mean, it wouldn't be surprising if, let's just take all the big cases, there are ones against every one of these companies. If you get court judgments in each one of them that says terrible abuse of market power, we're going to consider restructuring you. I think the first thing you're going to see is every one of those companies coming in and saying, look, we didn't break the law, but if you really think we did, we've got to abide by the US law. Look what we're doing in Europe. Look what we're doing in the UK. We're doing other things that don't require such a draconian intervention. So if these things actually happen in Europe and the UK, if they seem to work to create more choice, opportunities, open up markets more, I think it will drive its way, whether it's through settlements of cases, whether it's through the adjudication process, or if Congress can figure out how to do it itself. I think it will seep back in to the US ecosystem one way or the other.
I mean, that could happen like in the Amazon case, where they did settle in Europe and they did achieve, Europe achieved, I think, a lot of what they were really hoping to achieve. In California is where the lawsuit is for antitrust violations because they have a different set of rules. And I think there'll be pressure to try to just do in California. And then does California set US policy?
Yeah, I mean, that could be the case. There's also been rumors that the FTC is considering a monopoly case against Amazon. I mean, there could, there could be other private litigation that unfolds. This can develop in a variety of ways. Yes.
So from a very practical point of view, how do we get companies to stop like spamming our phone, our computer? How is this data used? And like, how do we just get it to stop? Like from the consumer perspective.
Oof.
I mean, like, oh yes, this all sounds great at a high level, but from the nuts and bolts of it, I would like to stop receiving phone calls every single day telling me about like, some like nursing care or something that they can offer me. How do I get this to stop?
Well, when you have a digital market unit in the UK that focuses on this, that then resides next to Ofcom, which covers all of media services in the UK, and they work closely together, you at least have a place to go to complain. To the extent the sharing of data with business users, the actual sharing of what works and what happens, the getting rid of all the opaqueness around how the platforms work, the marketplace theory would be that when you're getting spammed, you're getting mistreated, you're getting overcharged, or you're getting just abused as a consumer, some other commercial entity, if they can see into the system and a way to reach you, can offer you something to protect yourself or to give you the alternative where that stuff doesn't happen. I don't know if it'll really play out to be that competitive on platforms, but that would be the theory of how this should work. I mean, there are a lot of people who, because they see the dominance and know the theory of the lack of incentive to innovate when you control a dominant platform and you can keep others out, you don't necessarily pay as much attention to your consumers, your users, as you would in a competitive market. So the theory here would be by breaking that open, you're going to get better responsiveness. I don't know if it'll work.
But is there anything I can do in the interim to like stop being tortured?
There must be an app. I don't know. I don't know.
Well, there are.
Yeah.
Multiple apps, do not call apps that run against the point. I'll get notice of spam, or we'll just block it.
No, because it changes a phone number every time I block them. It's another day. It's another phone number.
The
Do you not call list? Okay, I will try that. I was like, who at the FCC, now that you're gone, that I like, do I complain to? I'm down to nuts and bolts and practicality here.
I don't have an answer for that, but I'm curious. We've been so far talking about the business strategy or like how this works at a high level. For cases where we need to understand how specific technology works or like very specific design choices work, and I'm thinking about issues where we, are talking about interpretability of certain models. It seems like there is a bit of a distance from people who are trying to regulate it, people who are actually working on these issues, and just like not knowing how much can we know at this point or can we regulate. Does any of this that we've talked about change when we consider those specific aspects of certain technologies that we just like don't know how they work fully yet?
Yeah, it's a great question. So the aspect of the UK law related to competition of experimentation and their open processes that they're promising through this, I think is the most ripe way of thinking about how researchers, those with technical skills, can keep monitoring for how this is all playing out. In the European model, the best tool that I've seen is under the Digital Services Act, where there is, and this is all more about content and how to limit hate speech and block illegal content online predominantly. There are substantial obligations of the platform companies to share data with trusted researchers and to require them to come up with risk assessments and independent third-party audits of their practices. So that should get at a lot of the kinds of issues of why is this stuff continuing to flow when it's supposed to be illegal or it's not supposed to be allowed, or why aren't you capturing it? Why aren't you catching it? Those are tools that are built into the laws, which again, I don't think we really have here, but I think Europeans and the Brits are trying to build that into these structures. Again, understanding that they're not going to nail it the first time. They need to learn more as they go to make sure that whatever regulatory structures they put in place are starting to work. We exhaust everybody's questions. John, you have more?
I think we've exhausted everybody's questions. I actually have another question, but I want to make sure everybody gets a chance. So one of the things that you talked about was this ability to amend for up to 10 years. And I think you rightly point out that this is an incredibly powerful tool. And when you think about how are businesses going to react like to that piece of it, you were speculating that maybe it'll bring them to the table to discuss more, maybe right. But I got to tell you, what businessmen hate is uncertainty. And my guess would be, and I'd be curious your reaction, my guess is they're only going to come to the table with more information and engage heavily if they somehow think that will reduce the uncertainty.
Yeah. No, I think those two actually can
Are they
coincide.
compatible?
I
That's
think
the
they
question.
I think they are compatible because you know better from being in the belly of the beast. But my experience with businesses is they don't think they're cheating in the marketplace. They think what they're doing is profit maximizing to serve their own interests and a set of customers. And if you say you have to do this new thing of sharing, or you have this new duty or obligation, they may be against it, but then they're going to look at it and say, what's my best way of doing that to still serve my customers and maximize my profits? And I think I know better than the government how to do that. And so I think there will be a strong incentive at least to come forward with all of that and have it be vetted by a public authority so that they can get the certainty that they're looking for. I'm not saying it's perfect, but I just think it creates knowing that someone is going to keep looking over your shoulder and has been not just, so right now, if you settle an antitrust case and there's a consent decree, usually it's a number of years, and it's for a set of purposes. It's in front of a judge. And then the companies go their merry way, but they don't want to get hauled back in by the government. But it's a cumbersome process. And mostly you think, I did what I said I was going to do. Now leave me alone. And for the government to come back in and reopen it, I got to go and tell this judge that maybe I didn't think about this one thing, or maybe something else happened and I didn't really know about it. And are they going to be sympathetic, or are they going to say, get out of here? You had your shot. You're supposed to do this, and don't bother me. I have new cases. When you have a law that says we expect you to adjust for up to 10 years what you're doing, because we don't expect you to be able to get it right the first time. And you have the right to make these guys sandbox experiment with remedy. I think it's kind of built in as an expectation that there are going to be adjustments.
Yeah, I mean, it could be an effective way to deal with a market where there's significant and dynamic innovation underway, right? Which is a real plus. I mean, that's a huge plus. And then when you overlay into that the fact that there are criminal liability for some individual managers if they're not complying with information, which was, I think,
the penalties can be severe.
I just know from like Sarbanes-Oxley that changed behavior fairly significantly. People were just a lot more, boards were just asked many more questions and were much more engaged. So all right, we're at the witching hour. I want to thank everybody for coming. On Wednesday, we have another topic or continuation of this topic. We have a study group titled, Will the UK's proposed digital platform regulation confirm or outperform Europe's DMA? So it's just a continuation of some of this discussion, and I would encourage all of you to come. And thanks for coming to this one. Yeah, this will.